you, Your Honour. You referred Mr Bates to the chair of the Risk Management Committee earlier, and we have a statement of his which is behind tab 8. I tendered that statement.
48(5).
Now, I take it that as chair of the Risk Management Committee, Mr Bates, he effectively reported back to the National Committee.
That's correct.
Of which you were a member.
Yes.
He says in his statement at paragraph 5 that he recommended that all branches have their child protection policies and procedures accredited or audited to ensure compliance with their own legislation. Has that happened, Mr Smith?
No, not at this time. The intention was, as I understand it, to approve the national policy, then implement the national policy, and then conduct the audit.
This is a slightly different audit from what you gave evidence about earlier. That audit involved compliance with the national policy. This is an audit to compliance with state and territory legislation.
That's correct. And the intent of the audit that I'm putting in place in New South Wales is really to inform the further work we may need to do to give full effect to the national policy and improve our policies and procedures. And then at some point we would then fall in line with the Scouts Australia intent to do a national accreditation.
Well, leaving aside the accreditation for the moment, this is asking you to have an audit of whether you comply with the legislation in respect of your policies. That hasn't been done?
Not at this stage, no.
It should be done, shouldn't it?
Yes, it should.
Is it on your list?
It is, yes.
It is now on your list?
Yes.
Now, Mr Ryan says that after assessing different external organisations, he selected Childwise to assist Scouts, and he refers to an audit or accreditation. Can I ask you, Mr Smith, whether or not what you are seeking is an audit or accreditation?
To clarify, what we are putting in place in New South Wales, we've called an audit, and it is, as I previously described, has three components. One is to test our practices against our policy and procedure. The second element is to compare our current New South Wales policy and procedure with the recently approved national policy and procedure. And the third element is to compare our New South Wales policy and procedure against the elements published by the Royal Commission in the July Creating Child Safe Institutions document. The intent around accreditation does incorporate the specific elements of ensuring compliance with relevant state and territory child protection legislations, and that was intended to be, and my understanding is still intended to be, a nationally coordinated activity for all branches of Scouts.
Notwithstanding the legislative requirements in each state are different.
That's correct.
Is it the intention that accreditation would be by Childwise?
I believe so. I'm not entirely clear on that. That intent was articulated some time ago, well before I took up the role.
Have you had, that is your organisation, had any involvement with the Australian Childhood Foundation?
Not to this point, but as previously indicated, we put out to tender identified six suitable organisations to be the recipients of a request for proposal for our audit. Australian Childhood Foundation was one of those. The tender evaluation has been completed and a recommendation has been included in board papers for the 12 December board meeting of Scouts New South Wales.
Thank you. Now, can I just turn to complaint handling when the complaints are in the hands of lawyers? Who's responsible for dealing with lawyers making claims against Scouts in respect of allegations of child sexual abuse?
That's primarily me, supported by the Child Protection Officer and the Administration Officer within Scouts New South Wales.
Do you have a firm of lawyers who advise you in this area?
Yes, a firm was appointed in September to provide a service to Scouts New South Wales in that regard.
Do you have a written process you follow in respect of being approached by lawyers or indeed survivors themselves who are seeking some form of redress?
In the letter of appointment, I did outline the intent of the support that we required from our legal firm, and that encompassed dealing with survivors and where they had appointed legal support, their legal representatives, and also liaison with insurance companies and other key stakeholders. I'm very mindful of the report of the Royal Commission into redress and litigation and the recommendation around having suitable guidelines documented and made available. There's a well-developed draft that's been prepared in conjunction with our legal support that gives effect to that recommendation. Additionally, in the direction to our legal firm, part of that process has been to write to survivors or their legal representatives where applicable, and put on the record what we're offering in relation to what we've called a restorative engagement process. And we outline that very
Before
clearly.
we get to the content of that, how do you identify the survivors to whom you write? Many circumstances are different in what we consider to be the number of active cases. They could be anything from a police inquiry, for which we have very little information, all the way up to a well-developed train of correspondence between either the survivor or the legal representative, more typically, and Scouts New South Wales. So what do you tell them you offer them in that correspondence?
We offer a genuine and empathetic apology in a form that's suitable to the survivor. We offer...
So you offer that in the correspondence?
Yes, we do.
So you don't make it in the correspondence, you offer that you will give it at a later time?
Well, we effectively make it in the correspondence and offer to provide that more formally, either in person from a senior representative of Scouts New South Wales or in writing.
What else?
We offer a restorative engagement meeting, so that will be an opportunity for a survivor to, to share their story with a senior representative of Scouts New South Wales, which would typically be myself or the Chief Commissioner. And we offer assistance in accessing counselling should that be required. Assistance,
does that come with money?
We'll treat every case on its individual merits. In the time, we'll treat every case on its merits, it's sure.
I understand that, but of the cases that you've treated on their merits, does it involve giving money for counselling?
We haven't had any requests for counselling that we've addressed at this time, but certainly if money's required, it will be allocated.
So you haven't offered counselling, do I take it?
We've offered in the letters assistance to access counselling, and should there be a requirement to fund it, we'll fund it.
I'm not quite sure what you mean by assistance to access counselling.
Well, there are a range of counselling services available more generally in the community, and some of those may be appropriate and useful to the survivor.
So is there any indication that the services you tell them about are services they should use?
Well, once again, this is early days, and the intent is to treat every case on its merits. Given the geographic location of some survivors, clearly some will have a preference for face-to-face counselling, and depending on where they're located, that might dictate which service providers are most useful to provide that support.
Mr Smith, you say the intention is to treat every case on its merits.
Yes.
I think what Ms Furness is trying to find out is what are the merits that you put into your framework.
Well, the merits.
What is it that you will respond to, and to what level will you respond?
In regard to counselling, when I say it merits, it's what I really mean is what the request of the survivor is, specifically.
But there's certainly going to be some requests that you're not going to meet, so you must have parameters within which you operate, understanding that there will be some discretion within those parameters.
We haven't set any boundaries in relation to counselling support at this point.
But what about historically? I mean, you've been dealing with claims, as I understand it, through the Scouts' participation in our redress roundtables with quite a large number of claims over time. So you said a minute ago that this is relatively new, but claims handling by New South Wales and Australia is indeed very unnew. It's you've been doing it for a long time. So what would have happened over the last 4 or 5 years?
I'm not familiar in detail to the practice prior to my taking up the appointment in May.
Well, surely you've reviewed the files.
Yes, I have, and my recollection is there hasn't been many, if any, specific counselling requests.
But just in terms of claims, do you have any? Could you advise the commissioners the number of claims that have been dealt with in the last 3, 4, or 5 years in New South Wales?
I don't have those figures.
Well,
on the top of my head.
surely the commissioner might.
Mr Tompkins?
We could certainly take that on notice.
But why would you not know that? I mean, that's fundamental. Any organisation would want to know how many claims, particularly under these schemes in the past, which has largely been a civil litigation environment.
Yes, well, I can certainly talk to the number of active case files we have now and claims and letters we've sent to survivors or their legal representatives.
Can I clarify something, and correct me if I'm wrong? My understanding, and again it's from the information Scouts has provided to the Commission in previous work relating to the redress report, that largely Scouts Australia and Scouts New South Wales leave most of their claim handling in the hands of their insurer. Is that correct?
I think there's been a focus in the past of pursuing the involvement of our insurer. And that's generally taken the form of researching relevant information and providing documents to the insurer.
Can I be more specific? Is it the case that previous to this new scheme, it was in fact the insurer that effectively ran the conduct of claims management in Scouts New South Wales?
I don't believe so, other than in one case in recent times. The insurers have generally declined to act and sought Scouts New South Wales to act as prudent uninsured.
But are you sure of that, or is that just your understanding?
Certainly in the case files that, other than one instance in our current active case files, that's the case.
Is it the case?
I understand, when you say the insurer effectively ran the conduct of claims, what were they doing?
No, I don't. I think my answer was that they haven't been in other than one case.
The insurer that effectively ran the conduct of claims management. I'm sorry, that's that's Commissioner Fitzgerald. So, is it the case that, irrespective of insurance, Scouts has been responding directly to claims?
Yes, that's correct.
And in so responding, you say you haven't had requests for counselling. Do you make plain to people that they can ask for it and that Scouts will pay for it?
That's certainly the process I've been adopting since I took up the appointment, which is why we've appointed lawyers. We have been in the process of writing through them to survivors that have legal representatives, and in one case I've written directly to the survivor offering in very clear terms that the offer of those 3 elements that I addressed previously.
So is that the standard practice? Is that an offer made to everyone? If they need it?
That is the offer being made to everyone currently.
So who determines the actual amount, not just the counselling support, but the amount that some people would call redress, others might call compensation? Who actually determines that?
We haven't offered any monetary redress
Ever?
payments, no.
Ever?
It's my understanding.
You're saying Scouts New South Wales has never settled a claim?
No,
Is that
we
correct?
have settled a civil claim, but we haven't offered a redress payment.
There's two systems that have been in place. There's primarily claims that have been dealt with by way of civil litigation up till very recently.
Yes.
And the claims dealt with under civil litigation were primarily dealt with by your lawyers.
Sorry, could you repeat that, Councillor?
Claims that have been proceeded by way of civil litigation have been handled by lawyers on behalf of
That's correct.
And to the extent there was an insurer, either the insurer indemnified you or chose not to indemnify you.
That's correct.
And when they didn't, clearly Scouts had to pay the money.
That's correct.
And those cases that were dealt with by way of civil litigation, generally there was a settlement before going to court, is that right?
Yeah, that's correct.
And there were few that were actually litigated in court.
Yes, I'm not sure of the numbers, but certainly in recent times one has settled prior to court, and I'm not aware of any others in the last couple of years that have gone to court.
And what you are seeking to do now is introduce a new system?
I'm seeking to make a very clear statement to all survivors through their legal representatives that we are offering those three elements of redress. We're reiterating our approach in terms of monetary redress, and that is best pursued through the Commonwealth Redress Scheme, which was recently announced.
So we know that the Commonwealth Redress Scheme is not up and running. So have you, consistent with the Royal Commission's report into redress, established a system that mirrors the recommendations for an interim scheme in that report?
My recollection of the narrative around interim redress schemes, particularly in relation to monetary payment, included a number of factors that make interim redress of monetary payments quite problematic. So the intent has been to focus on the three largely non-monetary elements and leave the monetary redress to the Commonwealth Redress Scheme.
Well, in the event that the Commonwealth Redress Scheme isn't established for some time, surely Scouts is going to enter into discussions with survivors that include a monetary payment.
Certainly we're open to discussions along those lines, but we haven't set a framework for monetary payments.
Well, a framework's set for you in the
Yes.
Royal Commission's report. There's nothing stopping you adopting that framework, is there?
There isn't, but we are mindful of the risks in putting an interim arrangement in place without the details of the Commonwealth Redress Scheme being known.
What are the risks?
Certainly, some of those include suggestions that Scouts or their agents or any construct that we put in place is not objective in terms of support to the survivor. And certainly in our discussions with No More and others, we've heard of discussion around other institutions that have had some difficulties there in terms of determining what's a just payment from a survivor's perspective.
Well, did you hear the evidence of YMCA yesterday?
Yes, I did.
They've set up a scheme, you understand that?
Yes.
They've got independent people assessing the monetary amount, and
Yes.
they've adopted the matrix set out by the Royal Commission,
Yes, I
and
understand
they've
that.
adopted a counselling process that involves payment,
Yes.
$5,000, I think,
Yeah.
and they've adopted a sum which would be the up amount of $90,000.
Yes, I understand that.
Anything to stop the Scouts doing something similar?
We could look. We could certainly do that. But I did note that clearly, even with an upper cap of $90,000, which is less than both the Royal Commission recommended and the Commonwealth Government has announced, then leaves open the question of whether that's adequate from a survivor's perspective.
Well, it's open to the Scouts to offer an amount that's either the same as the Royal Commission's report or
Yes.
what the Commonwealth's offered, isn't it?
Yes, it is.
There's no impediment to you offering whatever you think is fair from a survivor's point of view.
No, that's correct.
Is there any reason why you haven't gone down that complete path now that you're looking at restorative justice, I think was the term you used?
Restorative engagement.
Beg your pardon, restorative engagement.
No, frankly, in the short time that I've been in the role, that's as far as I've got in terms of this process.
But you understand the Royal Commission report is effectively a blueprint for what to do on an interim basis.
Yes, I do.
There's no reason not to follow that blueprint, is there?
That's correct.
Thank you. Do you have any?
I must say I'm struggling, if you can help me at the national level. Consideration of these issues, both redress and civil liability, have been active within the Commission and engagement with the Scouts for at least over 2 years. Could you help me to understand whether or not at the national level there has been a genuine attempt to put in place either a national redress scheme or amendments to the civil liability regime that are effectively applied in Scouts Australia?
Neville, as the redress coordinator, I'll get you to answer that.
Thank you. Commissioner, the National Executive Committee has in fact turned its mind to this on at least 3 separate occasions. Our position has been one of supporting the recommendations of the Royal Commission, and secondly, that we urged the Commonwealth Government to proceed with its announcements on the response to the Royal Commission. We hoped that the federal government would proceed to implement a single national redress scheme in 2017. That is not now the case, and we are concerned in terms of the delay to 2018.
Yes, but why is that the only reason the Scouts have delayed, rather than actually amending either its approach to civil litigation or alternatively implement its own redress scheme? Is it really that the Scouts Australia took the view that it would do nothing until such time as the Commonwealth scheme was either announced or some alternative put in place?
That is correct. We have been awaiting the position of the Commonwealth Government.
Do you think that's a fair approach to the survivors that were seeking some sort of either redress or active claim outcome?
It is not fair to the survivors, and our clear wish is that the federal government does in fact accelerate the implementation of the scheme.
Mr. Bates, can you help us with whether the branches other than New South Wales have a position similar to that of Ms Heaney?
Similar to?
Ms Heaney's position.
A child protection officer.
I'm not aware of the individual branches' application of those cases that Mr Smith's been talking about.
Leaving aside the cases Mr Smith's been talking about, the position that Ms Heaney took up recently in relation to child protection, is that position one that is available and or filled in other states?
Sorry, misunderstood. My understanding of New South Wales has led the way there. I haven't seen another branch appoint a paid person in that role. They deal with their cases through their office as a whole.
It would be consistent, wouldn't it, with your national policy for that position to be replicated in other states?
It could be, yes.
Do you have a view as to whether it is or is not?
is or a good view.
Is or is not consistent with the national policy that you've just introduced for that position to be in each state?
I think that it's perhaps it's a position that would be very helpful in a state who has had a poor record in this area. We do have some branches with no case, and so they are able to handle the issues still within the construct that they have. But it would be something that we're watching nationally to see how well this works within New South Wales, as to whether that would be something we would suggest for all branches to do. At this stage, it's not in our national policy.
Mr Bates,
Yes.
you need to be cautious about believing there are no cases where you don't know about them. The Royal Commission conducts a private session.
Yes, I'm sorry, I do understand that. I guess
And we have heard of such cases. My memory is in every state.
My apologies.
There's a national database in place, isn't there? In relation
Yes, there
to, does that national database have provision for complaints and or claims to be inputted?
It has provision for a person who has been alleged to be involved in any child protection matters to have their name flagged within that database.
So the database could be a means by which nationally you could understand the extent of the issues and where they are?
Yes.
Is it used to that end?
At this stage, we are rolling it out across our membership, and it is a product that has become very useful to us in understanding the issues that we have and ensuring that we allow only the right people to be participating.
What have you done as a result of information you've learned from the database?
That information would, as a branch, when they look to see if there's a name on there, they would investigate if that person is somebody of good character that we would accept as a member.
Mr Smith, you said you've engaged lawyers recently to assist in managing claims. Is that right?
That's correct.
Are they new lawyers, or are they the same lawyers that you've been using for civil litigation?
No, this is a new firm. They haven't been involved, to my knowledge, in recent times.
And their role is to assist you in cases that are part of your restorative program but not part of civil litigation?
I was mindful that many of the cases have different characteristics in terms of whether survivors have a legal representative appointed, whether a claim had been made, whether we understood who the insurer was, whether the insurer accepted that they had some responsibility to act. So it creates quite a complex environment. So the intent of engaging them was to provide a capacity and some obviously expert knowledge to help in the coordination of those cases, and in particular to improve our correspondence with survivors and their legal representatives. It is possible some of those will evolve into civil litigation, at which point we'll consider who's most appropriate to act for us.
Is it the case that your intention in respect of this scheme is to move people who are perhaps within the civil litigation process at the moment with you into this system and to prevent others going through civil litigation, but again channel them into this new system? Is that the intention?
Well, it really is a capacity to help coordinate whatever means those cases come to us, whether it be through civil litigation or even directly to us, so that we can provide a timely and consistent response. And we acknowledge that we haven't been doing that in the past.
timely being a key factor.
Yes.
You're aware there's been complaints in the past about the delay in responding to lawyers' claims and letters and the like.
Yes, I am.
And you're putting in place something to improve that?
Yeah, absolutely.
And part of that is engaging the new lawyers.
Correct.
And I assume that one of your instructions to them is to respond in a timely fashion.
Yeah, yes, and the process has been that we've provided all our active case files to them. The legal firm is well progressed in reviewing all those, providing an evaluation and recommendations, including draft correspondence, and I've issued instructions back in relation to into all of those that have been reviewed by our lawyers. Some of those letters have been released to survivors or their legal representatives, and in some cases, those, because they offer apologies and so forth, some of those letters are still awaiting advice back from the insurers, which we think are relevant to the cases.
How many survivors have you spoken to via your new lawyers in respect of your new scheme?
So four letters have been issued to date, 5 are drafted and with relevant insurers for comment, and we've had verbal and other indications back from 2 essentially accepting our offer for restorative engagement.
The insurers are ones that have accepted a responsibility for all claims that you might receive for child sexual abuse?
No, they haven't accepted responsibility, but they have agreed that the language and offers inherent in the letters are acceptable to them.
So that in the event something was accepted by a survivor, whatever was said wouldn't preclude the insurers from indemnifying you?
That's our intent in involving them in that part of the process, yes.
Can you just tell us your framework and your time frame for carrying out the audits and or accreditations that were determined, I think, in 2014, according to Mr Ryan's statement?
That'd be a national matter.
In terms of New South Wales, but the audits and or accreditations that New South Wales...
So the audit that we're conducting, as I indicated, will go to the board for approval and funding. They've given approval principle prior, and we've set ourselves a time frame of completion of that audit by 31 March next year.
And then presumably implementing whatever comes out of it.
Absolutely. As I indicated previously, we're mindful we're not embarking on this audit with the view that the auditor will verify that our framework is 100% complete and sound. We're embarking on the audit at the beginning of the process to help inform any actions that we may need to take. We thought it was very useful to expose our processes and practices to a third party to ensure that we had an objective view, and we're very willing to be transparent about that, and I fully expect that there will be a number of matters raised as a consequence of the audit that we'll need to address, and it's part of our commitment to continuous improvement.
Thank you. I think you've also consulted, have you not, with other agencies like the Ombudsman and Children's Guardian in respect of what you're doing?
Yes, I certainly had meetings early in my appointment with the Office of Children Guardian. I forget the title, but there were certainly several workshops convened by the Children's Guardian, and several meetings with the Deputy Ombudsman, and I've made the relevant introductions for our new Child Protection Officer to have those discussions also, and several of those occurred already, and there are more planned. We're also engaged with other not-for-profit organisations from time to time to seek advice, and including the YMCA, and they've been generous in providing advice and information.
Thank you. I've nothing further on it.
Any questions?
Only a brief one, Your Honour, just to Mr Bates. Mr Bates, you may have heard some questions being asked of Mr Smith and Mr Tompkins about an audit that was mentioned by Mr Ryan in his statement. Is there anything that you can offer the Commission by way of explanation as to the audit that he's referring to there?
Yes, the Risk Management Committee are working with all the branches on the implementation of the National Child Protection Policy, and we'll be assisting each of the branch to navigate their way through that particular implementation of that policy within their branch.
Sorry, if I could... I might ask the question in a different way. Mr Ryan, in his statement at paragraph 5, do you have that?
Number?
Tab 8 of the statements bundle. Mentioned in paragraph 5 at about the third line onwards, I recommended to the NEC that Scouts Australia and all branches should have their individual child protection policies and procedures accredited (audited) by an external organisation to ensure compliance with the relevant state and territory child protection legislations.
So here we're going to be working with the external agency Childwise to assist us in reviewing our practices.
And were they involved in conducting that audit?
Yes, they were.
And was there anything produced as a result of that audit that you were aware of?
No.
Were you party to any meetings where there was any reports back in relation to that audit that you can recall?
No.
Okay. I can't ask you a question, John.
I have a series of questions for you, Mr Tom. Can I, with respect to your previous role as International Commissioner, I was struck by the numbers attributed to the Scouts worldwide of 40 million members, most of whom I assume are children. Is that right?
Sorry, Commissioner.
Most of whom are children. Is that right?
That's correct.
In your role as International Commissioner, were you ever apprised of or acquainted with child protection policy or guidance from the international organisation?
Yes, Commissioner. Each time a contingent from Scouts Australia attended an international event such as a World Jamboree or an Asia Pacific Region Jamboree, we were each required to complete child protection module, which got to the very heart of the need for each national Scout organisation to have in place policies of child protection.
However, you have recognised as an organisation that your child protection stance was inadequate because you've introduced an enhanced and improved policy. Am I therefore to assume that the international body is also behind, or has been behind, in that respect?
Absolutely, Commissioner, and so much so that the World Body of Scouting has in fact issued quite a thorough framework in which every national Scout organisation, including Australia, needs to develop its own policies.
And has that guidance affected the development and design of your national policy, or vice versa?
That is correct. It has helped to inform the development of our national child protection policy.
So you regard what you're doing now, which is a new policy, as consistent with or ahead of the international body?
At the very least, it is consistent with. In some areas, I would suggest, Commissioner, that we're actually leading. In other areas, we have much to learn from other organisations.
Turning to you briefly, Ms Heaney, I may have a mistaken impression, so I'd like you to correct it if I do. I've had the impression that the Scouts Australia national policy is very much focused on adult to child potential for sexual abuse or sexual misconduct. In your training and in your policy, are you also alert to and paying attention to what we would describe as sexually inappropriate behaviours between children?
Absolutely, yes.
And is that as much focus as you have on adults?
Very much. Any form of inappropriate behaviour with a sexual content to it is treated in the same way.
You're answering for New South Wales. Would you say that's the case for the other states?
I obviously can't speak for Scouts Australia, but my understanding and my interpretation is that it deals with abuse, and that abuse is categorised by the form of the behaviour, not necessarily by the age of the person.
So you're alert to sexually harmful behaviours between children?
Very much so, and we have specific mention within our New South Wales policy of such behaviour.
Thank you.
Can I just ask a question in relation to the fact that you're a federation and many NGOs operate as federated organisations, and we heard that yesterday with the YMCA. So I just want to understand the national level, Mr. Bates or Mr. Tompkins, in your national capacity, does the National Executive Committee obtain information from each of its state and territory branches in relation to the number of child sexual abuse allegations that are made from time to time? Does it collect that data?
We don't, at the National Executive Committee, gather that data. Through our redress coordinator, we've looked into some things. Neville?
Commissioner, at the national level, the reliance at the moment would be on the national flag system, and that is increasingly becoming an important tool for measurement.
But just being specific, if I can, just for one moment, for example, the child sexual abuse allegations that have been referred to by New South Wales, would you receive a regular update or report of allegations received by the branches? Or how would you become aware of the allegations that's taking place across Australia?
Currently, well, in the past we've not received that information. With our new policy, what we're looking for is a all-inclusive approach, and as we're rolling this out and trying to implement it, we've got the Risk Management Committee working on how we keep everybody informed of what's happening, and that goes to the membership database, it goes to how we as a organisation are dealing with child protection.
But just the National Executive Committee, which is effectively the national board of Scouts Australia, how does it inform itself that it is in fact a safe organisation across Australia if it's not getting regular reports?
Yes, as a result of this national policy, the risk management team are working out how we can do that. They're looking at all the methodology, and they have to deliver something back to us at our next meeting by March. So Mr. Ryan, as the chair, is working with his risk management committee to develop a formula or a set of statements that would help us.
But up until this stage, the national body doesn't receive these sorts of reports.
That's right.
And the second thing is in relation to the coordination of the claims, whether it's a civil litigation matter or a redress matter, does the National Executive Committee have an oversight in relation to consistency and equity across the organisation to ensure that a victim in one state is treated fairly relative to victims in other states?
With the federated model, each branch is a separately incorporated body, and so they deal with their individual member within their branch.
Sure, but Scouts Australia, would it not be an organisation that promotes equity and fairness across the nation?
We do.
So wouldn't it be a logical outcome, therefore, that the National Executive Committee would want to ensure that payments, either as settlements in civil litigation matters or redress payments, are in fact fair and equitable across the nation?
Yes.
So how do you achieve that?
That's something that we're going to have to look at now that we've got our new policy and we have all the branches committed to a new way forward as to what do we do as a Scouts Australia.
Would it be too harsh to say that the National Executive Committee and Scouts Australia has failed to appropriately address those issues of national consistency, national equity in the past?
Yes.
And you believe that the measures that you've...
Would it be too harsh or not too harsh?
Is it a fair comment?
It's a fair comment. We struggle with our federated model.
And have there been particular hurdles or obstacles, which are very, we understand in federations, but have there been particular areas, states, territories, or particular individuals that have withstood the pressure to have a greater national oversight, national consistency, national equity across the organisation?
Can you rephrase that? I'm sorry.
Have there been particular holdouts in your organisation that have slowed the progress to getting a genuine national approach, or has there been general agreement across the states and territories to the directions you're taking?
I'm not aware of anybody holding out. My understanding is that branches are proceeding with their cases as they get them. You heard from Mr Smith that we were looking for a national redress, but it's not stopping us proceeding as cases come by.
And if a particular jurisdiction or branch failed to institute the policies in an appropriate way, what are the disciplinary mechanisms, if at all, that Scouts Australia can apply to the state and territory branches?
That's something we still have to investigate. We don't currently have anything.
Okay, thanks.
You're not alone in struggling with a federated model in a national space. But there are issues which must be addressed.
Yes.
But as you say, it's intolerable that in relation to children and adverse consequences that a national organisation doesn't present a national response.
Yes. Yes.
Mr Bates, one of the benefits of accreditation, we have been told, is that if a federal member, a member of the federated body, did not match the standards of the rest of the body, accreditation could be withdrawn from them, which is a form of sanction. Is that an attraction to you in your quest for accreditation?
I hadn't heard of that before, but it seems, yes, it does. As Your Honour just said, each of us struggles with this federated model, and how do we, as a national person, I have no members. I have the branches that I have to appease or reach out to. So right here, right now, yes, that sounds attractive.
Well, you wouldn't be aware of it, but I would refer you to our work on sports clubs.
Okay.
The device that is a disciplinary mechanism within the whole sports arena is who's accredited to who and what follows from that accreditation.
Thank you.
And there is a case study on that that's available.
Thank you.
Number 39?
Really, Commissioner?
39. Number 39.
Nothing further. I'll say that I have to tender some documents. In the statement volume, at tab 1 is a response of Scouts New South Wales dated the 1st of June 2016.
It'll be 48.6.
Tab 2 of that volume, Scouts New South Wales update report dated 1 September 2016.
It'll be 48.7.
Behind tab 4, submission on matters relating to child protection from Scouts dated 17 November 2016.
It'll be 48.8.
Tab 5, answers to supplementary questions dated 22 November 2016.
It'll be 48.9.
Nothing further, Your Honour.
Well, can we thank all of you for your contribution today and for the work that you do on behalf of the Scouts. it would seem that there's still work to be done in your organisation, probably quite a lot, to bring a national response or effective national response to these problems. Can I say that the Commission understands the frustration with the delay in the implementation of a national redress scheme? We're heartened by the fact that progress is being made, but we share with you the sense that it would be a good thing if it happened quickly. But for today, can I thank you, and you are now all excused, and we'll adjourn.
Thank you, Your Honour.